What happens when your neighborhood association just decides to cancel its own election? Well, that's exactly what happened in one community, and it sparked a whole legal battle that came down to a single word in their rulebook. This is a story about rules, reason, and what happens when people vote to make their own HOA disappear.
So let's just get right to the heart of it. Can they do that? Can your neighborhood board just decide to skip an election altogether? You'd think it's a simple yes or no, right? But as we're about to see, this case is a perfect example of the strict letter of the law, crashing right into the messy reality of what's actually going on.
All right, so first up, let's get into the details of the dispute. And hey, if you've ever lived in a place with an HOA, this whole story, the rules, the regulations, the little disagreements, it's probably going to sound pretty familiar. Okay, so at the center of all this, you've got two main players. On one side, there's Clifford Burnes. He's a homeowner who calls himself a stickler on detail, and that's a key part of the story. And on the other side, the Saguaro Crest Homeowners Association. It's a pretty small community, just 18 lots, and their board felt like they were doing the totally reasonable, common sense thing. Now, just in case you're not totally up on the lingo, let's quickly talk about HOA bylaws. Think of them like the Constitution for a neighborhood. Seriously, they're the official rule book that says how everything is supposed to work, and, you guessed it, they are smack dab in the middle of this whole thing. You know, this whole thing didn't just pop up out of nowhere. It all goes back to an annual meeting in December 2021. The meeting happens, but no election. A whole year goes by before Mr. Burnes files a formal complaint. And that's what eventually leads to a legal hearing in March of 2023. So yeah, it took a while to get here.
So what was the homeowner's argument exactly? Well, it all came down to the super specific wording of just one rule in their own bylaws.
Okay, take a look at this. This is the exact text that this whole case is built on. It's from their bylaws, Article 2.1. It says an annual meeting shall be held for the purpose of electing directors. Now, for Mr. Burnes, those phrases shall be held and for the purpose of, they were everything. His argument was actually pretty straightforward. In legalese, the word shall isn't a suggestion. It means must. It's a requirement. So in his view, the rule was black and white. The meeting must happen, and its purpose must be an election. No election? Boom. The board clearly broke their own rules. Simple as that. But the HOA had a completely different take on it. Their whole defense rested on one giant piece of context that they believed changed absolutely everything. And here's the twist, right? At that exact same meeting where the election didn't happen, the community members voted, and it wasn't even close, 11-1, to completely dissolve the HOA. I mean, they were literally voting to make the association disappear.
So that was the heart of the board's defense. They were basically saying, hold on, why would we hold an election for a new board for an organization that's about to not exist? It just didn't make any sense to them. It felt totally pointless.
And the HOA board president, Esmeralda Martinez, she laid it out perfectly in her testimony. She said, look, if that vote to dissolve had failed, we absolutely would have held an election. My term was ending. The only reason they skipped it was because the community had just voted to shut the whole thing down.
And that's the legal standoff right there. You've got the homeowner saying, shall is absolute. The rule must be followed, period. And then you have the HOA saying, for the purpose of just states a goal. And hey, look at the context. The vote to dissolve makes that goal completely irrelevant.
So you have this deadlock, two totally different ways of reading the exact same rule. This is what the judge had to figure out. So, who won? Really, it all boils down to this. The bylaw says shall. So, did the HOA break the rule? Yes or no? And the judge's decision was no. The HOA did not violate the bylaw. They won. Okay, so the big question is why? How did the judge get there? Well, his reasoning had three main parts. First, he said the bylaw didn't create an absolute requirement. It said the meeting was for the purpose of an election, which is different. Second, he agreed that the context, the dissolution vote, was key and made an election pretty pointless. And third, and this one is huge, the homeowner never actually objected during the meeting when it was all happening.
Yeah, the judge really zeroed in on that point in his final written decision. Basically, by not saying anything at the time, the homeowner gave up his right to complain about it a year later. It's a legal idea, sometimes called waiver. If you don't speak up, you might lose your chance. All right, so let's pull back a bit. What does this one neighborhood spat teach the rest of us? Well, it actually says a lot about how rules get interpreted when they meet the real world.
There are a few big lessons here.
First, context can sometimes be more important than the exact words on the page. Second, speak now or forever hold your peace isn't just for weddings. Failing to object when something happens can really hurt your case later. Third, judges often lean toward what seems practical and reasonable. And finally, it shows that even rules that seem super rigid, using words like shall, can have a surprising amount of flexibility.
And that really leaves us with a big question to chew on, doesn't it? When it comes to our own communities, what's more important? Sticking to the letter of the law, no matter what, or looking at the spirit of the situation, the context? There's definitely no easy answer to that one.